Welcome to the debate. Before we jump into things today, please hit that like button, subscribe, follow, and turn on the notification bell so you stay updated on all our future discussions.
Yes, absolutely. Please do.
So today, we are diving directly into a really harrowing case from October 2025. This involves a 38-year-old man named Corey Hickey out of Eatonton in Putnam County, Georgia.
Right, the cyber tip line case.
Exactly. He was caught following a report from the National Center for Missing and Exploited Children, and, well, his charges are just severe. Multiple counts of the sexual exploitation of children, creating child pornography, and rape. It culminated in him getting 5 life sentences in prison.
Which is staggering. I mean, it is a horrific case. And when we see someone capable of those kinds of acts, the immediate instinctive reaction as a society is, how do we guarantee this never happens again?
Right, which perfectly frames our central question today. How should society manage convicted sex offenders to ensure maximum public safety? I argue that the United States model, which relies on publicly accessible registries and really strict post-sentencing residential restrictions, well, they are absolutely necessary tools for community defense against severe predators.
I get that instinct. I really do. The public wants transparency. But my perspective is that taking these extreme measures, which are designed for the absolute worst predators like Hickey, and applying them as a broad blanket public policy actually undermines public safety. Making these registries universally public and enforcing draconian residency restrictions, it destabilizes offenders, it manufactures homelessness, and frankly, it generates more risk than it mitigates.
But consider what you're asking communities to give up here. The U.S. framework, driven by things like Megan's Law and the Adam Walsh Act, mandates public access across all 50 states.
Right, but...
And defending residency restrictions, it's just common sense boundaries. Keeping offenders physically away from schools, parks, daycares, it inherently minimizes the opportunity for reoffense. And other countries are even beginning to see this value. Like Queensland, Australia, they just recently launched their first public registry under Daniel's Law, specifically to empower citizens.
Well, Queensland is really the exception there, not the rule. If you look at the broader international standard, places like Canada with their NSORS system, the UK's VISOR, New Zealand, they all maintain incredibly strict tracking databases.
But they aren't public.
Exactly. They explicitly restrict access to law enforcement only because they looked at the data and realized that public portals act as a catalyst for vigilantism and chaos, not actual safety.
Wait, they keep the public completely in the dark? Like, entirely?
They do. Because here in the U.S., our public notification laws trigger this disastrous socio-psychological domino effect. When you put a name and a face on a public website, that person gets fired, they get evicted, they lose stable employment and community ties, which clinical psychologists tell us are the only actual guardrails against reoffending.
I hear you. But think of a public registry as a community's immune system. A body cannot fight off a pathogen if it doesn't even know it's there.
Okay, but...
Let me just finish the analogy. Public awareness acts as the white blood cells. It deters the offender, who knows they are visible, and it equips parents to proactively protect their children. Because, let's be real, law enforcement simply cannot be on every single street corner.
If we're using the immune system metaphor, I'd say what the U.S. has is a severe autoimmune disorder.
How so?
Because an overactive immune system attacks the healthy body itself. When an offender loses everything and has no ties left to society, they don't just sit there. They go underground. They drop completely off the grid. Now, law enforcement, the actual doctors in this scenario, they can't track them at all.
I think you're focusing too much on the digital registry failing because it drives people underground. But what about the physical restrictions?
The buffer zones, you mean?
Right. Even if they aren't on a website, enforcing physical buffer zones around schools provides a very tangible layer of defense. It's essentially zoning law. We don't put industrial toxic waste dumps next to elementary schools because the proximity creates an inherent physical risk. Buffer zones break the physical proximity required for grooming.
It is incredibly counterintuitive, I know. As a parent, your very first instinct is keep them physically away from the playground. But when we look at data from the Association for the Treatment of Sexual Abusers, the foremost experts on this, they explicitly state there is zero empirical research linking physical proximity to a park or school with adult recidivism.
Zero research. Are you sure about that?
Completely sure. Because predators don't typically snatch strangers off playgrounds, they operate by building circles of trust within families or close networks. So these hyper-restrictive buffer zones end up being just, well, performative politics.
But they do create a boundary, even if.
A boundary with a devastating mechanical reality. When you have overlapping buffer zones that leave literally 0 legal addresses in a city, you get the 10 cities we saw under bridges in Miami, or out in Suffolk County, New York, where they were forcing people into isolated trailers.
Look, I understand it creates logistical burdens, but
It's way more than a burden, though. It escalates into this eternal punishment. Like in Missouri, there's a law forcing offenders to turn off all their outside lights and hide in their homes on Halloween.
right, I've read about that.
And in Texas, civil commitment, where offenders are kept confined even after serving their prison sentences, it has effectively become a shadow prison system. Practically no one has been released in 15 years.
Okay, but that level of caution doesn't come from nowhere. When you look at someone like Corey Hickey, who systematically exploited children, the state has a clear obligation to cast a very wide net to catch escalating patterns. The Adam Walsh Act includes varying tiers and even juvenile offenders, precisely because we need to monitor individuals who might escalate before they reach Hickey's level.
But that exact wide net approach is mathematically and practically flawed. It catastrophically dilutes the registry. When you try to catch everything, you end up prioritizing nothing. Did you know juvenile convicts account for up to 25% of registrants in the U.S.?
Wait, 25%? That high?
Yes. Human Rights Watch has documented children as young as 9 years old being placed on registries just for peer experimentation.
Wow, 9 years old?
Yeah. Under laws like Michigan Penal Code 750.145C, consenting teenagers who share explicit photos with each other get branded with the exact same child pornography label as severe predatory adults. That completely breaks the utility of the registry.
So it floods the system with non-predatory cases.
Exactly. If cops have to spend valuable resources verifying the address of a teenager who sent a photo, they have fewer resources to track the violent predators who actually pose a threat.
Well, to synthesize where we're at, while the system can definitely be blunt, I still maintain that public registries and strict geographic boundaries remain the most effective, transparent tools available. A community cannot defend itself in the dark. The justice system's primary directive has to be protecting the innocent from individuals capable of profound harm, and transparency achieves that.
And I look at the international model and see a much better way. A law enforcement-only database, combined with housing stability and clinical rehabilitation, is empirically proven to result in fewer victims. We shouldn't let the immense emotional weight of these horrific crimes push us into passing laws that inadvertently make society more dangerous by creating desperate, untrackable people.
I think where we absolutely converge today is the reality that the current system is buckling under its own weight. We both agree that any framework failing to differentiate between a genuinely dangerous predator facing 5 life sentences and a teenager caught in a severe legal trap over a photograph, well, it needs serious refinement.
Precisely. We deeply disagree on the mechanics of achieving it, but our ultimate goal is identical: the absolute reduction of child victimization. Examining these international frameworks really forces us to challenge our assumptions about domestic policies.
Definitely. There's so much more to explore regarding how different jurisdictions balance rehabilitation with community defense. Thank you for joining us for this analysis. Please remember to like, subscribe, share, and follow the show so you don't miss our upcoming discussions.